All right, that's due in 30 days. Let's take a look at what your driving record said for that day. Your license was expired, so it wasn't anything terrible, and you renewed it.
Correct.
So very good. Yeah, you don't have much baggage on your license at all, but you don't want to undo all that. At least you told me the truth, which I appreciate. You can't drive home. If you get pulled over, they impound your car, it's cold out, so you need to call somebody to come get you. On allowing another to violate the motor vehicle code. That's $200. So this whole episode costs you $350, but it isn't going to suspend your license. $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. I'm going to give you an additional month to pay that. Make it due by 3/26. 3/27. Let's see what day of the week that is. It's a Friday. So you owe $150 on the civil infraction within 30 days, which is February 27th. The misdemeanor, you owe additional $200 by March 27th. You're going to call somebody to come get you, so you don't screw this up. Once you get on the driving suspended merry-go-round, it's very hard to get off of it. And you're working on getting off of it. So don't get stopped driving without a licensed driver in the car till you get your first permit for your full license. All right, you're good to go, Ms. Sawyer. Thank you for your patience. All right, that finishes our misdemeanors. We got a number of people here on the pre-exams. We'll take a break in a minute, but we got plenty of resource here. We got Mr. Gabriel, we got Mr. Robert, and we got Ms. Campfield. Yes, Ms. Harden?
I apologize. Mr. Clark is my only case. Judge Judson wants me and Mr. Gabriel upstairs at 9:45 for Mr. Rainey's arraignment and status. Would it be possible to take Mr. Clark's case up first?
Certainly. Where is he? Mr. Clark, would you come forward? Morning, Mr. Gabriel.
Morning, Your Honor.
All right.
This courtroom session starts routine, then suddenly turns serious. James Clark is facing an evidence tampering charge tied to a shooting at the Harvey House bar. He's not accused of firing the gun, but prosecutors say he removed it from the scene. Now, Judge Middleton has to sort out whether this ends in a felony or a deal.
This is file number 252565FY, People versus James Clark, charged with tampering with evidence. There were several of these defendants charged in this manner from an incident that happened at the Harvey House bar last May 3rd of 2025. This charge, let me pull it up here. alleges that on May 3rd in the village of Constantine, that you did knowingly and intentionally remove, alter, conceal, destroy, or otherwise tamper with evidence offered in an official proceeding. The way that is charged, that's a felony punishable by up to 4 years and a fine of up to $5,000. Mr. Gabriel, what's the
The stakes here are huge. Tampering with evidence is charged as a felony, carrying up to 4 years in prison and a $5,000 fine. But the prosecutor says this case is unusual because Clark wasn't part of the actual fight. That opens the door to a cooperation deal, and that could completely change the direction of this case.
circumstance here?
Your Honor, somewhat novel. Just indicate to the court that Mr. Clark and later this morning, Ms. Willis, have both been charged with this tampering. It involves the removal of a firearm from the scene of the shooting that occurred at the Harvey house. So the statute seems to totally fit the facts. However, they weren't involved in the actual physical altercation. At least Mr. Clark thus far has agreed to cooperate fully with the prosecution of the 3 individuals that I have charged with physically assaulting the individual who's now in prison for shooting some people. So what I'm doing is offering him an opportunity to enter a plea to attempted resisting or obstruction the police officer. It would be Officer Drew Hall, who was the main officer handling the shooting. I did defer sentencing for 6 months. During that time period, Mr. Clark, through the assistance of his attorney, will cooperate fully in the prosecution of the other 2 Mr. Clarks, and I can't remember the name of the third. All of those individuals are charged with aggravated domestic violence. And we anticipate those will be resolved shortly afterwards, so that all goes well. Within the next 6 months, we'll be moving to dismiss the case.
All right.
We do have the gun back. It was provided to us by the second individuals that gained access to it.
Laura, could you help me with something? All right, that's a lot to unpack. Now let's try it. If Miss Willis was here, I wouldn't have to do this twice. Would you make me several copies of this? Sure. What you're charged with is a felony, punishable by up to 4 years in prison and a fine of up to $5,000. According to Mr. Gabriel, what you're alleged to do closely fits the statute. However, they're willing to dismiss the felony charge for a plea to a misdemeanor charge of attempting to resist or obstruct a police officer. Attempting to resist or obstruct a police officer is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000.
Here's where the legal strategy kicks in. Judge Middleton explains that the felony could be dismissed if Clark pleads to a misdemeanor, cooperates, and stays out of trouble for 6 months. That's a deferred resolution, not a free pass. And when Clark says, kind of, about promises, it shows exactly why judges carefully lock down every plea detail.
We're also agreeing to defer this for 6 months under the deferral statute. There's a specific order, which I'm going to use here, Judge Pattison provided to me last year, where I will show that you enter a plea of guilty and set the sentence out for 6 months. If you cooperate with testimony and otherwise meet your obligations, if you don't get in any other criminal trouble, the charge would be envisioned to be dismissed by the prosecutor. Ms. Harden, is that your understanding of the plea agreement?
Yes, Your Honor.
Is that yours, Mr. Clark, as well? You provided me with a written waiver of your rights, but you were also in here when I went through the rights and heard me go through them. Do you understand by entering this plea, you're giving up your rights to have a trial?
Yes.
Anybody threaten you to get you to plead to this?
No.
Or promise anything?
Kind of. I mean, just promise that it'd be dismissed.
All right. Now, in the context of this case, I did, in a prelim or some other hearing, see the video of this incident in the bar. There were a couple different angles of it. And so were you at the Harvey House bar that day, May 3rd? and a scuffle broke out between two different factions. And I'm not sure which faction you were in, but were there shots fired there in the bar?
Yes.
And somehow did you become in possession of this gun that was used?
Yeah, while a couple people were scuffling, I ran over and took the gun from 'em.
All right, and what did you do with it?
I basically took it outside and freaking out and just gave it to Mrs. Willis, who at the time I didn't know that's who it was.
This is the key moment of the hearing. Judge Middleton gets the defendant to say it clearly on the record he took the gun during the scuffle, carried it outside, and handed it to someone else. That statement becomes the factual basis for the plea. Without it, the deal could fall apart. Was that panic or criminal tampering?
All right, so you took a piece of evidence from the crime scene and took it outside and gave it to somebody else?
Yeah.
All right, that's probably sufficient. Are you satisfied with that, Mr.?
I am, Your Honor. Thank you.
Miss Harden?
That's a factual basis, Your Honor.
All right, well, let's pick a date. Today is January 27th. 1, 2, 3, 4, 5, 6. Take us to July 27th. I don't know if I'm here that day.
It's our hope, Your Honor, that the other cases will be resolved and my client's cooperation will be completed by that time. And it'd be my assumption that if the prosecution has everything they need, they would dismiss without hearing. So if the court needs to adjourn that date, just to kind of
All right,
lock
we'll
it
set it
in.
for July 27th,
7/27.
26 at 10:30.
Now the pressure shifts to what happens next. The plea is in, but the outcome still depends on Clark's behavior. He has to cooperate, follow all bond conditions, and stay out of further trouble. If he does, the case may be dismissed. If not, this deal could unravel fast. That's the real tension in deferred cases.
I'll do a deferral order
Thank you.
in there. Does that finish your obligations here this morning?
Yes, Your Honor, thank you so much.
All right, I'll see you next week. Thank you, Mr.
Thank you.
Gabriel.
Thank you.
And the
Your Honor.
same offer applies in Miss Willis?
It will. Mr. Davison is talking with her. I think he's still talking with her.
All right,
Mr. Clark's good to go?
yes, he is. Mr. Clark, your bonds continued. It's $2,000 PR bond. All the conditions that were in effect remain in effect. All right.
Thank you.
This is file number 252399FY, People versus Meredith Franklin, Perk II. Mr. Perk was here previously. I think Mr. Gibson was appointed to represent him. We were here in December. He indicated at that time that he was going to be retaining you, and the matter was adjourned, and he followed through on that, and you filed an appearance in this matter. The matter was already adjourned once on January 13th and scheduled for today. What's the circumstance here today?
Your Honor, since we were at court last time, I have gotten the opportunity to read the police report, which was not something that I'd had when we were here on the 13th. I then contacted the Michigan State Police, people who had been involved in the investigation. Long story short, Your Honor, I have now been in contact with a trooper who is able to get to the Marshall location. We have an appointment on Monday afternoon at 1 o'clock. I think that there's a possibility that we will be waiving the preliminary examination, but before I can advise Mr. Perk about that, I do need to see the underlying evidence in this case. And so I'm scheduled to do that on Monday. I do believe that at that point, I'll be able to talk to him about what to do. I had spoken with Mr. Robert about the possibility of keeping the exam on, then if we decided to waive, and that just seemed a little bit messy.
Well, the problem with that is they have to serve subpoenas. They're, that could be messy. All right, 2 weeks, we'll keep it on my docket.
Perfect.
Is that acceptable to you, Mr. Robert?
Yes, it is.
May I make a request, Your Honor?
Yes.
Is there a way that we can have the paperwork so that if he does decide to waive, I can just get it over to the court so that we don't have to come back and do the
Yes.
waiver in person?
Yes. Sue, would you so Laura, would you print out a waiver of preliminary examination in the Meredith Perk case for us?
And then is Your Honor willing to just accept the paper without us going on the record to do the waiver?
Yes.
Perfect. Thank you.
All right, 2 weeks from, don't leave yet.
Oh, we're not leaving yet.
No, I got more to say.
Sorry. I told him to leave, so.
I
don't
usually
leave.
do. Today is January 27th. We will continue this until, well, the problem is it's odd and even, and so I'm February 17th, not February 10th. Let me look, make sure I got it right. Judge Welty set this docket up system many years ago before I got here, so that's 24 years ago, but it's based on odd and even numbers of the week. I have things on certain even numbered days and Judge Pattison has them on other days. My prelim day is on the odd number day of the week, so I'm going to continue this to February 17th. (2026) at 8:30. Pre-exam conference. Preliminary examination, if needed, would be February 24th at 1 o'clock. Mr. Perk, I did allow you to leave the state of Michigan to go to Indiana for employment purposes.
Yes, Your Honor.
You're still working in Indiana?
I have been attempting to. The weather has been problematic for sure, but yes, I have a project basically doing construction work for someone on their attached garage.
All right. The evidence here is sensitive in nature. She's gonna meet with the MSP on Monday. Monday would be January 2nd. Thank you. Here is a waiver of arraignment or of
Thank you,
preliminary
Laura.
examination form.
Thank you very much. Perfect. Appreciate that, Judge.
One thing that stands out here is Judge Middleton's courtroom style. He keeps the docket moving, explains legal issues clearly, and still makes sure the record is precise. That balance matters. In cases like this, where a plea deal, cooperation, and evidence all collide, the judge's control of the courtroom helps everyone understand exactly what is at stake.
Mr. Perk, all the bond conditions that were in effect in this case remain in effect. As far as I can tell, you've complied with all the conditions of your bond. I want you to continue to do so. And your next court date is February 17th at 8:30. Unless your lawyer tells you otherwise, you're good to go.
Thank you, Judge.
Thank you.
Mr. George, what have you got for me?
I've got 4 cases.
All right, I haven't had a break since 8. Let's see where we are. Mr. George is here also, and Mr. Robert. Let's go through these if we know. Mr. Gibson, do you know what we're doing with Daniel Ashbrook?
He's asking for an exam.
All right, we'll make a record on him in a minute. Bradley Chapman, he's apparently in the back. He's not in the back. Bradley Chapman.
I've spoken with counsel, Your Honor. He was going to talk to his client, but we thought he was here, so we do have something to place on the record.
All right, we'll come back to that one. Have a seat, Mr. Mitchell. Joseph Full,
It's gonna be a plea, Your Honor.
that's yours now, Mr.
Yes, sir.
Oops. Lee Gowdy.
He's asking for an exam.
Is he in custody?
No,
Travis Gentile.
he's asking for an exam.
We also have a bond violation issue in that case. He's in custody, is that correct?
Yes,
We're gonna ask for an adjournment on that one.
All right, we'll have to bring him up by Zoom. Michael Moore,
he's asking for an adjournment because he's indicated that he's trying to hire, he's supposed to be hiring private counsel. So I would ask for a 2-week adjournment on that one.
all right, we'll make a record on him as well. Justin Moss,
Your Honor, Mr. Upshaw and myself are ready to address that on the record. We would, however, ask the court if we could approach about potentially going off the live stream
All right,
for
we're-
that case.
we're gonna shut everything off here in a minute, so
Okay,
we'll address that.
thank you.
Okay, Mr. Denton Patterson. Good morning, Mr. Patterson. What are we doing with him?
He's gonna be an exam next week.
Well, we're gonna be busy next week. Robert Racette.
He's executed.
Well, Mr. Racette, let's do him, get him out of here. You need methamphetamine like you need 3 holes in the head. This is file 26-43FY. Mr. Racette and I at one time spent a lot of time together working on some things. You've waived your preliminary examination in this charge and agreed to have the matter bound over to circuit court. Is that true?
Yes.
Are you still plugged into AA?
No, I haven't been for years, but I don't drink.
Well, you don't drink, but you traded one.
I'm not proud.
All right. Well, I was proud of the fact that what you did accomplish, and you haven't had a drink in probably 8
Still have
years.
it, yeah.
Well, you don't need this.
No, I don't.
All right, this matter will be bound over to circuit court. The conditions of your bond remain in effect. And your next case will be in front of Judge Stutzman. You're good to go.
Thank you.
Thank you.
Alan Reinickle.
He's asking for an exam.
We're gonna have 3 CSC exams next Tuesday. That will be quite a day. All right, we'll address him also. Craig Rudisil.
He's going to be entering a plea today.
All right, we'll put him in the plea file. Lindsay Willis is Mr. Davidson's case, and is she gonna accept the misdemeanor offer?
No, deferred prosecution unit,
Yeah, but it's a plea with a deferral.
I guess.
Okay.
Yes.
We did the other one. I had hoped she had been in here so she could hear everything, but you guys were out discussing the case. All right, so we've got a number of cases to address. We'll stop the record here. And we will be back in a few minutes. We'll shut off the record, shut off the live feed.
This case shows how one decision in a chaotic moment can become a serious criminal issue. Clark admitted he removed the gun from the shooting scene, and Judge Middleton made sure that fact was clearly placed on the record. If you found this case as shocking as we did, be sure to like it, share your thoughts in the comments, and don't forget to subscribe for more amazing courtroom analysis.
And everybody can have a donut. If we only had a donut.